morning. This is your Kelso Report for Thursday, April 26th, and I'm your host, Clark Kelso. We have cases today involving revenue and taxation, attorney's fees, immigration, juvenile law, First Amendment, and arbitration. We begin with the Supreme Court of the United States, which had a revenue and tax case. These are always statutory interpretation cases, of course. Now, in general, a tax deficiency must be assessed against a taxpayer within 3 years after the return is filed. But that period is extended to 6 years when a taxpayer, quote, omits from gross income an amount properly includable therein, which is in excess of 25% of the amount of gross income stated in the return, close quote. And that's section 6501E1A. Well, in United States v. Home Concrete and Supply, the taxpayers overstated the basis of property they had sold, which of course resulted in an understatement of their gross income, and it was by an amount in excess of 25%. Now, relying largely upon its prior decision in Colony v. Commissioner from 1958, which interpreted virtually identical language in the Tax and Rev Code, the Supreme Court held that the 6-year statute was not triggered, since overstating the basis of property is not the same thing as, in the language of the statute, filing a return that omits an amount from the statement of gross income. According to the decision in Colony, the statute is focused on situations where specific items of income are simply left out. And the language in the code was not intended to reach a case where gross income was misstated because of mistakes in inflating the basis for property that was sold. In other words, overstating the basis is not the same thing as omitting an amount. Next, we turn to the Ninth Circuit and attorney's fees. In the trial court in Western Watersheds v. Department of the Interior entered an award of attorney's fees to a plaintiff conservation group in a long-running dispute involving federal grazing permits in Idaho. The award included expenses incurred in administrative proceedings that occurred before the district court action was filed. The district court ultimately concluded that the agency had acted arbitrarily and capriciously in issuing certain permits. Applying the U.S. Supreme Court's decision in Sullivan v. Hudson, the Ninth Circuit held that the fees related to the administrative proceedings were improperly awarded, since under 28 U.S.C. section 2412, fees for administrative proceedings can be awarded only when the proceedings have been ordered in a district court action that remains pending until the conclusion of the administrative proceedings. These proceedings came long before the district court action, so the fees were not awardable. Next, an immigration case. Federal courts are generally without power to review the actions of consular officials. There are 2 recognized exceptions to the rule. First, where the suit challenges the failure of the consular official to take some required action. And second, a court has jurisdiction to review a consular official's actions when the government denies a visa without a facially legitimate and bona fide reason. In Rivas v. Napolitano, a consular official denied a visa on the grounds that the applicant allegedly admitted during his interview that he had committed a crime by encouraging other aliens to enter the United States illegally. The applicant then submitted a letter seeking reconsideration, which the consulate never responded to, claiming that they had never received such a letter. Well, based upon mail receipts showing that the letter had indeed been received, the Ninth Circuit held that the consulate had a mandatory duty under the applicable regulations to respond to the request for reconsideration, and so the federal district court had jurisdiction to order the reconsideration. The applicant also argued that although he had admitted being arrested for encouraging other aliens to enter the United States illegally, he actually was not convicted. He was arrested but not convicted, and so his visa request should not have been denied. The Ninth Circuit remanded the case so the lower court could work out the remaining factual disputes between the parties. Next, we have a case involving competency of a minor to stand trial. In People v. Alejandro G., the 4th District published that portion of its opinion which affirmed the Superior Court's finding that the minor defendant was competent. As the Court explained, it published it as a reminder of the proper test of a minor's competency, since the doctors who had evaluated the minor applied the incorrect test, and on appeal the minor's counsel also misconstrued the test. The proper test of a minor's competency does not hinge on his or her education regarding or knowledge of the juvenile court system. Instead, the correct test of competency is whether the minor has sufficient present ability to consult with his lawyer with a reasonable degree of rational understanding, and whether he has a rational as well as factual understanding of the proceedings against him. No more is necessary, and no less is sufficient. Next, we have a Section 300 proceeding in juvenile court. In J.M. v. Superior Court, the 2nd District rejected the mother's writ of mandate, petition for writ of mandate, seeking to reverse the juvenile court's order, bypassing family reunification services and setting a permanent plan hearing regarding her 2 minor children under Section 300 of the Welfare and Institutions Code. The statute requires a finding of abuse and neglect before the court can issue a jurisdictional order, and the California Supreme Court is currently considering whether the abuse and neglect standard requires a showing equivalent to criminal negligence or whether something less will suffice. But that legal issue was beside the point for the 2nd District in this case, because the juvenile court's jurisdiction ruling was supported by really overwhelming and compelling evidence that satisfied even the higher criminal standard of neglect and causation. In particular, the mother had embraced a drug lifestyle, living in a full-blown drug house. She had immersed herself in a culture of illegal drugs before and after the death of her 5-year-old child, who died from oxycodone intoxication. All of her children, her other children, were aware that she used illegal drugs and imitated her smoking drugs from a glass pipe. On the evening of her 5-year-old's death, she permitted a drug seller to provide her with stolen prescription drugs and then stay overnight in the residence. So the mother wantonly and recklessly exposed her children to illegal drugs and made them easily accessible. That's sufficient evidence to support the jurisdiction finding under any standard of neglect. Now, a trespass and First Amendment case at a grocery store. The right of a religious group to solicit donations in front of the entry and exit doors of a Ralph's Grocery was before the 2nd District in Ralph's Grocery v. Missionary Church. The church claimed an unfettered right to solicit donations on Ralph's property, arguing it was a commercial location open to the general public. That's good enough. But that is not the law in California. Even if it were a forum open to the public, Ralph's has the power to establish reasonable time, place, and manner rules, and the church in this action presented virtually no evidence concerning the attributes of the store or the sidewalk area or its ability to comply with Ralph's rules. Absent this evidence, it was not clear that this particular store was even a public forum under the Prune Yard decision. And faced with a broad and unsubstantiated claim to unfettered access, the 2nd District held that the Superior Court properly granted summary judgment to Ralph's in its action for trespass, and properly issued an injunction keeping the church solicitors 20 feet away from the sidewalk and apron area at the entrance to the store. Finally, we have an arbitration decision in Connecta Alternative Financial Solutions v. Superior Court, where the 2nd District, applying the U.S. Supreme Court's decision in Stolt-Nielsen v. Animal Fields International, held that under the Federal Arbitration Act, a party may not be compelled to submit to class arbitration unless the arbitration contract provides a basis for concluding that the party agreed to do so. The arbitration provision in Connecta expressly limited arbitration to the arbitration of disputes between the parties, and made no reference to and did not authorize class arbitration of disputes. Accordingly, the parties did not agree to authorize class arbitration, and the 2nd District reversed the trial court's order denying Konetka's motion to dismiss the class claims. And that's it for today's Kelso Report. Have a great day in the law.